Every US visa story begins with one of three ingredients: love, talent, or money. And today, we're talking about talent. There's a myth I hear constantly from highly accomplished professionals. My employer is doing nationally important work. I supported major projects. So my EB-2 National Interest Waiver should be automatic. But that's not how the law works, because immigration officers are not asking whether your company is extraordinary. They're asking whether your proposed endeavor and your role in advancing it justified waiving the normal labor certification process. And that distinction causes many otherwise impressive cases to fail. I'm Harry Tapias, CEO and immigration attorney at Loigica. And in this video, I'll explain why participating in important work is not always enough and why USCIS actually evaluates in an EB-2 National Interest Waiver case. EB-2 National Interest Waiver is one of the most powerful employment-based green card pathways. In qualifying situations, it allows someone to pursue permanent residence without going through the traditional PERM labor certification process. But this category is often misunderstood. Many applicants believe, I worked at a famous company, I supported important clients, I contributed to major initiatives, therefore I qualify. Working at a great company may help, but prestige does not transfer automatically. USCIS still wants to understand, what is your endeavor? What is your contribution? And why does your future work matter? Today, EB-2 National Interest Waiver cases are generally analyzed under a framework called Matter of Dhanasar. And the government is usually asking three major questions. First, does your proposed endeavor have substantial merits and national importance? This is where many people get surprised. The question is not, was your employer important? The question is, what are you trying to do? For example, a software engineer supporting national cybersecurity, a physician improving healthcare access, an infrastructure expert modernizing transportation systems, a researcher advancing a specialized technology. The endeavor, not the employer, is what matters. The second question is whether you are well positioned to move that endeavor forward. This is where your individual story becomes critical. USCIS may look at education, experience, publications, patents, leadership, business growth, prior outcomes, industry recognition. And this is where many cases become weak, because applicants spend pages describing the company when they should be proving themselves. Your resume should not disappear inside your employer's success. The third question becomes, why the United States waive the normal labor certification process? This does not mean proving that no American could ever do your work. It means showing that your future contribution has enough value that requiring the traditional process may not be necessary. And this is where I see strong cases emerge. Not because the person worked near impact, but because they can continue creating impact. The biggest mistake I see is confusing access with contribution. You may have worked at a major hospital. You may have worked inside a Fortune 500 company. You may have supported nationally important projects, but the legal question is still, what role did you play? What have you accomplished? And what are you positioned to do next? This is where EB-2 National Interest Waivers cases are won. If you want our legal team at Loigica to evaluate whether your background supports a strong national interest waiver case, contact us at the link below. And remember, every US visa story begins with one of three ingredients: love, talent, or money. See you in the next video.